Hello everyone, this is Vivek Anand, Assistant Professor at Thakur University. Now we are going to discuss an important aspect of audit, that is company audit. And company audit consists of various important topics. They may be as qualification of a company audit, means who will be eligible to appoint as an auditor of a company. Next is disqualification of a company auditor, means what are the factors that make a person to be not appointed as a company auditor. These are called as disqualification. Then we discuss appointment of company auditor. After that, manner and procedure of appointment of an auditor by the company. Then audit committee. Casual vacancy. Right to powers an auditor. Duties of an auditor. Liabilities of an auditor. Audit report and audit certificate. These are the segments which we will go under the head company audit. So let's we start first qualification of an company auditor. Qualification of a company auditor is governed by the section 141 subsection 1 and 2 of Companies Act 2013. So and the eligibility or qualifications of a company auditor, first is a person shall be eligible for appointment as an auditor of a company only if he is a chartered accountant. Chartered accountant means C. As per Chartered Accountants Act 1949. CA Act makes a CA to become a company auditor to hold the valid certificate of practice, that is COP. So, for the appointment of a person, it is compulsory that he have to be a chartered accountant as per CA Act 1949. Another eligibility, a firm. A firm may also be a chartered company auditor of a company, whereas majority of partners practicing in India are qualified for appointment as aforesaid may be appointed by its firm name to be auditor of a company. Means a firm of chartered accountants may be qualified for appointed as company auditor in the name of firm, and any of the partner of the firm can do the work of auditing in the audit firm on behalf of the CA firm. But in case of a partnership firm, company appoints the firm, not a partner individual. So in case of firm, the firm become an company auditor, not their members individually. Suppose CA firm A, B, C have various members like CAA, CA Mr. B, CA Mr. C, CA Mr. D, and up to the limit of number of 10. Then appointment of company auditor in the name of CA firm ABC, not in the name of CA Mr. A, CA Mr. B, CA Mr. C, and up to the number of 10. So, in a CA firm, the CA firm become a company auditor, not their partner in individual capacity. The second eligibility, where a firm include a limited liability partnership LLP is appointed as an auditor of a company, then only the partners who are chartered accountants shall be authorized to act and sign on behalf of the firm. its explanation is as means if a LLP become a company auditor, then LLP is company auditor and their partner may be work as an auditor, but only those partners who are chartered accountant. Non-CA person cannot be authorized on behalf of firm to do the audit work and to do the signature at any paper or statement related to audit work. So, in individual capacity, only a CA is permitted to become a company auditor. Or in case of a firm, in the name of firm, the auditor may be appointed, not in an individual capacity. Okay, so these are the qualifications to become a company auditor. Now, some disqualifications are also there that prevent a person to become a chartered accountant. These are governed by Section 143, subsection 3 and Rule 10 of Companies Rule 2014. So, the following persons, as per the Companies Act Section 141, subsection 3, shall not be eligible for appointment as an auditor of a company. We discuss all these disqualifications. Point A, a body corporate other than a LLP registered under the Limited Liability Partnership Act 2008. So, a body corporate other than LLP will not be eligible or disqualified to be appointed as an company auditor. Next point, an officer or employee of the company cannot be company auditor in the same company. Next point, C, a person who is a partner or who is in the employment, means employee of an officer or employee of the company. This point explains that any partner or employee of a officer of the company or employee of the company cannot be the company auditor in the company in which the person is officer or employee. Point D, a person who or his relative or partner. In this case, person includes relative or partner also. First explanation regarding the point D. A person who or his relative or partner is holding any security of or interest in the company or its subsidiary or of its holding or associate company or a subsidiary company of such holding company in which the person who or his relative or partner. Second explanation, a person who or his relative or partner is indebted to the company or its subsidiary or its holding or associate or subsidiary or such holding company in excess of rupees 5 lakh. If the limit is in excess of 5 lakh, then disqualification is exist. Up to the limit of rupees 5 lakh, disqualification is not there. So the limit have to be very carefully analyzed. Third explanation, a person who or his relative or partner has given a guarantee or provided any security in connection with the indebtedness of any third person to the company or its subsidiary or its holding or associate company or a subsidiary company of such holding company in excess of rupees 1 lakh. Again, the limit is in excess of rupees 1 lakh. So up to the rupees 1 lakh, disqualification is not there. So in the case of explanation B and C, means point number 2 and 3 have to be analyzed very carefully. They provide the limit up to for qualification, but excess of rupees 5 lakh in explanation 2 and in explanation 3 rupees 1 lakh may attract disqualification. Next point E, a person means auditor or a firm who, whether directly or indirectly, through in the capacity of agent or in the capacity of relation, has business relationship with the company or its subsidiary or its holding or associate company or subsidiary of such holding company or associate company, then the person is also disqualified for the appointment as a company auditor. These are the restrictions which prevent a person to become a company auditor. Let's discuss next point E. A person whose relative is a director or key managerial person of the company, then the person who is relative will not be eligible to be appointed as a company auditor in that company. Next point G. A person who is full-time employment elsewhere, or a person or a partner of a firm holding appointment as its auditor. And if such person or partner is at the date of such appointment, on the date of such appointment or reappointment, holding appointment as auditor of more than 20 companies, then he will also not allowed to be appointed as company auditor. Emphasize on this point: full-time employment and holding appointment as auditor of more than 20 companies. 20 companies is a ceiling limit as per Companies Act 2013. Next point H. A person who has been convicted by a court of an offense involved fraud and a period of 10 years has not elapsed from the date of such conviction. Under the 10 year, the person will not be allowed to be appointed as an auditor. Convicted person involving fraud. Next point I. A person who is directly or indirectly rendered any service referred to in section 144 of the company, its holding or its subsidiary, then he will also attract the disqualifications and cannot be appointed as the auditor of this company. So these are the points related to the disqualifications of company auditor towards a auditor. So if a person falls in these points or attract these points, then he will not be allowed or eligible to become a company auditor. Again, section 141 subsection 4 says what? If a person appointed as an auditor of a company incurs any of the disqualification specified in section 143 subsection 3 means all these are point from A to I. He shall be deemed to have vacated his office. Such vacation shall be deemed to be a casual vacancy in the office of the auditor. So what is here? We see that if a person appointed as an auditor and this situation attract after the appointment of auditor. So section 141(4), it applies when the auditor appointed as an auditor means he accepts the auditorship, then disqualification attract means after the appointment of a person as a company auditor, if any disqualification referred in the above points attract him, then he shall be deemed to have vacated his office. And this type of vacancy of company auditor is treated as casual vacancy and filled up as the filling of casual vacancy. Okay, so for the disqualification, a body corporate, a partner, relative or partner, a person of auditor who directly or indirectly as an agent or in relation, a person whose relative, a person in full-time employment or in connection to the ceiling limits, a person having convicted person or a person directly or indirectly rendered any other services. These are the main points that make disqualified a person to become a company auditor. If he is eligible, then he will be the company auditor by the process of appointment. Now, let me discuss the appointment of company auditor. These are based on the eligibility. So, first, appointment of the first auditor. Appointment of first auditor is governed by section 139 subsection 6. This is in the case of non-government company. So, appointment of first auditor in the case of non-government company. First point, the first auditor of a company other than a government company shall be appointed by the board of directors, only by the board of directors, when within 30 days from the date of registration or date of incorporation of the company. This section imparts that when a company is incorporated or registered, from that date up to the 30 days, board of director are authorized to appoint a company auditor. Next, in the case of failure of the board to appoint such auditor, means if board of director fails to appoint the auditor within the 30 days, then board of directors shall inform the members to the company, who shall appoint within 30 days at an extraordinary general meeting. So, if the board of directors cannot appoint or fails to appoint the company auditor, then they inform the members of the company, and the members in a general meeting, in a extraordinary general meeting, appoint the company auditor within the 90 days. And the first auditor shall hold office from the date of appointment till the conclusion of the first AGM. Means, what is the tenure of this first auditor in non-government company? The tenure is up to the conclusion of first AGM from the date of appointment of its auditorship. So, in case of non-government company, board of director is authorized. If he fails to appoint the company auditor, then members in an extraordinary general meeting appoint the company auditor, and the auditor appointed in this process will hold his office up to the date of conclusion of the first AGM. Now we discuss appointment of the first auditor of government company. It deals by the section 139 subsection 7 of Companies Act. For a government company or any other company owned or controlled by central government means CG, SG means any state government, CG and SG means partly by central government and partly by state government. Here, any other company means government company and any other company that is owned and controlled directly or indirectly by the central government, state government, and a combination of central or state government. In these type of companies, the auditor will also appointed as like as the government company. So appointment of first auditor of government company appointed as first auditor shall be appointed by the CAG, Comptroller Auditor General of India. CAG, Comptroller Auditor General of India, within 60 days from where? From the date of registration of the company or incorporation of the company. In case of the CAG does not appoint such auditor within the prescribed period, that is within 60 days from the date of registration, then board of director of the company shall appoint such auditor within 30 days. If in case of failure of board of director to appoint such auditor, it shall inform the members of the company within next 30 days, and the members shall appoint such auditor within the 60 days at an EGM, extraordinary general meeting. Extraordinary general meeting. So here the first authority is CAG, second authority is board of director, and the third is members of the company. Then what is the tenure of this type of auditor? The auditor so appointed shall hold office from the date of appointment till the conclusion of the first AGM. Actually, we are discussing the appointment of first auditor. So, in case of every type of first auditor, whether it is appointed in a government company or in a non-government company, the tenure till the conclusion of the first AGM from the date of its appointment. Let me refer appointment of first auditor of non-government company. What is it? The first auditor shall hold office from the date of appointment to till the conclusion of the first AGM. And in case of government company, again we find that auditors so appointed shall hold office from the date of appointment till the conclusion of the first AGM, means the tenure is same up to the conclusion of first AGM from its appointment. In case of government company, the first authority is board of director. If board of director fails, then the second authority to appoint company auditor is members of the company. In case of government company, the first authority is CAG. If CAG fails, then second authority is board of director. If board of director fails too, then the final authority is members of the company to appoint the first auditor of the company. So in case of non-government company, there are two authorities. First is board of director, second is members of the company. And in case of government company, to appoint the first auditor, there are three authorities. First is CAG, then board of director, and last, members of the company. So there are not more and much difference between the appointment of first auditor in case of government company or non-government. Straightforward government company governed by section 139 subsection 7 for the appointment of first auditor. It also includes any other company that is owned, controlled, whether directly or indirectly by central government or state government or combination of the state government and central government. Then the provisions applicable to the government company will also applicable to these companies. Now, subsequent auditor. Subsequent auditor means each and every auditor that will be appointed after the first auditor. They are called as subsequent auditor. So now we discuss appointment of subsequent auditor and reappointment of auditor. This is governed by Section 131, subsection 1 and Rules 3 and 4 of Companies Rules 2014. Let's have a look. First point. Every company shall at the first AGM, annual general meeting. Every company shall at the first AGM appoint an individual or a firm. Firm includes LLP also. Every company shall at the first AGM appoint an individual or a firm as an auditor of the company. Every company means all the companies incorporated under the Act, which includes one person company also, and ordinary resolution is sufficient to appoint an auditor. So, for the appointment of subsequent auditor or reappointment of auditor, the rule is every company shall at the first annual general meeting appoint an individual or a firm as the company auditor. Every company means all the companies incorporated under the Companies Act, including one person company. And in this annual general meeting, only ordinary resolution is sufficient to appoint an auditor. What about tenure of this type of auditor? The auditor shall hold office from the conclusion of first AGM till the conclusion of its sixth AGM. Means when the first auditor is appointed, that to hold the office from the date of its appointment to the conclusion of first annual general meeting. And here the appointed subsequent auditor or reappointment of auditor is done in the first AGM, and this type of appointed auditor will hold his office in the capacity of company auditor till the conclusion of its sixth AGM. Sixth AGM. That is for 5 years. That is for 5 years. Appointment takes place only for 5 years. It means no company can appoint auditor for less than 5 years. The annual general meeting in which he is appointed is counted as first AGM. So, for the appointment of subsequent auditor and reappointment of auditor, the annual general meeting is treated as the first AGM for the appointment of that particular auditor, and he will hold his office in the capacity of company auditor till the conclusion of sixth AGM. Means he will be appointed for 5 years, and in which he is appointed, that AGM is counted as first AGM. Okay, let me have a look on the appointment of auditor that is governed by section 138 with the help of a chart. Actually, this is the summary which provide assistance, help to recall, to revise the concept of appointment auditor. It is a summary that saves the students time at the time of revision. But to understand this summary, it is necessary to go with the detailed concept of appointment of auditor, whether it is subsequent auditor, whether it is appointment of first auditor in the government company, and whether it is appointment of the first auditor in a non-government company. So here, appointment of auditor under section 139 have two categories. The first is first auditor, second is subsequent auditor. First auditor means the first time appointment of a person as a company auditor, and subsequent auditor means the auditor which is appointed after the retirement the first auditor. First auditor means which hold his office in the capacity of company auditor till the conclusion of first annual general meeting. So, first category, first auditor. First auditor, in case of other than government company, that is governed by section 139 subsection 6, appointed by board of director when within 30 days from date of registration or date of incorporation of the company. Here the first appointing authority is board of director and time limit is within 30 days from the date of registration. If board of director fails to appoint the auditor within the prescribed limit, that is 30 days from the date of registration, then they will inform to the members of the company and members will hold an extra general meeting and within 30 days they will appoint the company auditor. So, in case of first auditor in non-government company or other than government company, the first appointing authority is board of director and will appoint the auditor within 30 days from the date of registration. If it fails, then they inform the members of the company and members of the company arrange a extraordinary general meeting. Then they will appoint the company auditor within the 30 days. And this appointed auditor will hold his office in the capacity of company auditor till the conclusion of first annual general meeting from when he is appointed as a company auditor. Okay. Now, the next segment of first auditor is appointment of company auditor in a government company. Appointment of company auditor in a government company. Government company and any other company which is owned or controlled directly or indirectly by the central government or by the state government or by the combination of state and central government. In this case, first authority to appoint the auditor is C and AG, Comptroller and Auditor General of India. CAG appoint the first auditor within 60 days from the date of registration of the company. And if C and AG didn't appoint the first auditor within the prescribed limit, that is 60 days from the date of registration, then for this failure, the next appointing authority or first auditor is board of director. And board of director will appoint the first auditor within 30 days. Again, if it is found that board of director is also failed to appoint the first auditor, then after this failure, They will inform about the non-appointment of a company auditor to the members of the company, and members of the company will arrange an extra general meeting, and within 30 days they will appoint the first auditor. Then what about the tenure of this type of appointed auditor? Yes, the auditor so appointed will hold his office in the capacity of company auditor till the conclusion of the first annual general meeting. First annual general meeting. From which date? From the date of appointment is as first auditor. So, in case of first auditor, we have discussed in a summary two segments: appointment of first auditor other than government company and appointment of auditor in the government company. Now, the second part, that is appointment of subsequent auditor or reappointment of auditor. In the case of non-government company and in the case of government company. In the case of non-government company or other than government company, the appointing authority is members of the company in annual general meeting. And what about the tenure of so appointed auditor? He will hold the office from first AGM to the sixth AGM, subject to fulfillment of certain conditions in which he was appointed. That is count as first AGM, means he will be appointed for 5 years. Second segment of appointment of subsequent auditor. This is in case of government company. Appointing authority is C and AG, Comptroller and Auditor General of India. CAG appoint the auditor within 180 days from the commencement of year. And what about the tenure of this type of appointed auditor? The auditor so appointed will hold his office till the conclusion of the age. Till the conclusion of the age. So, this is the summary chart which imparts us about the appointment of first auditor in case of government company and other than work. It also imparts about the appointment of subsequent auditor in case of government company and other than government company. So, this chart will help all you students while you are going to revise the concept of appointment of auditor. It will save your time. It will more clarify your understanding of this concept. But this is the suggestion. First, you have to go to the detailed concept. After reading of detailed concept regarding the appointment of company auditor, whether it is first auditor, whether it is subsequent auditor, then you can take this chart as a summary or as a reference. Okay. Have audit committee, board of directors are the competent the auditor. What is the manner and procedure? Let me start from the recommendation of audit committee. Audit committee recommended the name of auditor for appointment of board of directors. So the process is start from the recommendation of audit committee and forwarded to the board of directors. What was the consideration by the audit committee towards a candidate to forward this appointment to the board of directors is qualification and experience. Qualification and express. So, first, the audit committee observed the qualification and experience of the candidate to be appointed as company auditor, and these observations or candidature recommended or forwarded by the audit committee towards the board of directors. Now the ball in the hands of board of directors. Board of directors. If the board of directors is agree with the candidature recommended by the audit committee, then he may go with the yes option. Means board of directors recommend the same auditor to the members in the AGM, and AGM will appoint the auditor. But there is the point side of the option, that is no. Means if the board of directors did not agree with the candidature forwarded by the audit committee for the appointment of auditor, then board of directors can refer back the audit committee with reasons. Means board of directors has an option to send the recommendation back for reconsideration by the audit committee for the appointment of company auditor. So, after the reconsideration of the audit committee towards the candidature, he may send again the candidature to the board of directors. Again, there are two ways. First, recommend the same person as auditor. Means for the person for which the audit committee get back his recommendation from the side of board of directors. Then audit committee recommend the same person as auditor, or recommend the another person as auditor. So in the option of recommendation the same person as auditor, it means audit committee did not agree to the board of directors reason. Board of directors can send its own recommendations to members in AGM by noting the reasons for its disagreement with audit committee. Means board of directors can send its own recommendations for the person that is forwarded to the board of directors from the side of audit committee for the appointment of company auditor. And this is the person who is the same which already has been priorly sent back to the audit committee for reconsideration. In the second option, if audit committee recommend another person as well, if board of directors agrees to it, it recommends the same auditor to the members in the AGM. Otherwise, above cycle will continue. Above cycle means if the board of directors did not consider the recommendation of the audit committee, then they can send back the candidature towards the audit committee for its recommendation. So normally we can summarize this process as that audit committee observe the candidature of the person to be appointed as company auditor in terms of qualification and experience. Then audit committee send this candidature to the board of directors for appointment. And if board of directors agreed with the recommendations provided by the audit committee for appointment and auditor, then board of directors recommend the same auditor to the members in the AGM. When auditor appointed, if board of directors did not agree with the recommendation sent from the side of the committee, then board of directors can send back this candidature to the audit committee back for reconsideration. After reconsideration, audit committee can send the same name or have an option to send the another person's name to be appointed as auditor. Then board of director, if find himself to agree with the audit committee, then auditor will be appointed. Otherwise, he can send back the recommendation provided by the audit committee for reconsideration. Until the auditor is appointed, this process or this cycle will continue. Okay, so this is the practical background. What is the behind the appointment of auditor? What is the manner? What is the procedure for appointment of auditor? Now, the entity should obtain written consent. Means after the recommendation received by the audit committee and agreed with the board of director recommend the same auditor to the members in the AGM, and the entity should obtain written consent. Means when the auditor is going to appoint, the auditor should obtain written consent and a certificate before the appointment is made at annual general meeting. What about auditor should clarify that regarding his appointment that, or actually this is the process. Means when the annual general meeting is going to, or when the members is going to appoint the auditor should clarify that what is point A, individually or in case of a partner of firm, he is eligible for appointment and is not disqualified for appointment under Companies Act, under CA Act, and rules or regulations made there under. Point B, auditor should clarify that the proposed appointment is as per the term provided under the Act. Point C, the auditor should also clarify that the proposed appointment within the limit, that is ceiling limit, laid down by or under the authority of the Act. D, the auditor should clarify that the provided list of proceedings relating to the profession matters of conduct against the auditor or audit firm or any partner of the audit firm pending with respect to is true and correct. After the clarification provided by the person to be appointed as auditor, company appoint the auditor as at AGM by passing ordinary resolution, and thereafter the company should. Means after clarification provided by the person who is a candidate to be appointed as company auditor, when he clarifies all these points, then company appointed the person as company auditor in the ordinary resolution, in the annual general meeting by passing ordinary resolution. After that, what company should do? Company should give the information of appointment of the auditor. That is, it should write a letter to the auditor by attaching extract of resolution in the minutes of annual general meeting in which the person is appointed as company auditor, and inform ADT1 of such appointment with the registrar within 15 days of the meeting in which the auditor is appointed. From ADT, one will be filed by the company only once in 5. Means the company just give the information regarding the appointment of the auditor to the auditor who is appointed and to the registrar. Information to the auditor should attach the extract of resolution in the minutes of annual general meeting in which the auditor is appointed, and information regarding the appointment of auditor should be sent within the 15 days from the date of that meeting in which the auditor is appointed with the prescribed form, that is ADT1. So this is the manner and procedure behind the appointment of auditor, where company should clarify from the side of person who will be the company auditor. And company is also liable to provide the information regarding the appointment auditor to the auditor also and to the registrar. Now we will discuss term and rotation of auditor. These are governed by section 139 subsection 2 and rule 5 of Companies Rule 2014. Rotation of auditor is a new topic introduced in the Companies Act 2013. As per the provisions, a company should rotate auditors after a specified time. So, in section 139 subsection 2 of Companies Act 2013, company rotate their auditors after a specified time. It means the same auditor cannot continue forever. Same auditor cannot continue forever. And after a specified time, when the auditor is changed by the another auditor, this is called as the rotation of auditor. On what basis a company do this? Let's discuss the terms for rotation. Rotation is applicable to listed companies, other prescribed class of companies, but it did not include one person and small company. Means the rotation of auditor is applicable to the listed company and other prescribed class of company except one person and a small company. What is that? Point A. All the unlisted public companies having paid up share capital, paid up share capital equal to or more than 10 crore. Point B. All the private limited companies having paid up share capital equal to or more than 50 crore. Or all the companies having public borrowing from financial institution or banks or public deposits equal to or more than 50 crore. Means these are the type of companies on which the terms of rotation of the auditor is applicable. Listed companies, all other prescribed class of companies. Prescribed means unlisted companies having paid up share capital equal or more than 10 crore, all private limited companies having paid up share capital equal or more than 50 crore, all companies having public borrowing from financial institutions and bank or public deposit equal to or more than 50 crore. So, the above companies shall not appoint or reappoint. Shall not appoint or reappoint any individual as auditor for more than one term of 5 consecutive years. Consecutive means 1 by 1, 1 by 1, 2 in a series. And an audit firm auditor for more than 2 terms of 5 consecutive years. Cooling off period, an auditor who completed the term as discussed above, that is individual 1 term of 5 years. In case of firm, 2 term of 5 years, is not eligible for reappointment as auditor or 5 years. This is the rotation technique that is based on some terms. And rotation of auditor is provided by the law only for that purpose that same auditor cannot continue forever. Because if only a person will be the company auditor again and again and again, then it may be a scene of collision between the company and auditor. Yes, it may be seen. Perhaps this thinking may be developed in the members or investors or suppliers, that why a same person will be appointed as a company auditor again and again and again. There should be some rotation. So on these observation, the companies at 2000 introduce the new topic, that is term and rotation of auditor. These are applicable to the some companies, listed companies, and prescribed class of companies. Prescribed class of companies included unlimited limited public companies, private limited companies, all companies with a limit of 10 crore, 50 crore, or 50, as the case may be. And rotation or restriction is also for the individual and firms. Okay, so this is the term and rotation of auditor. One thing more very important about the term and rotation of auditor, cooling off period. This provide the that cooling off period is as the completion of 5 years in case of individual capacity of company auditor, and 2 terms of 5 years each in case of firm of a C. Means if a firm is a company auditor. And if we analyze the terms of rotation of auditor, then we find that this section is not applicable to the 1-person company, small company, and if we take the reference of rule 5, then dormant company will also included in this exception. Means we can conclude as that rotation of auditor is not applicable to 1-person company, small companies, and for dormant company also. It is very important for the rotation of auditor. We have to check these criteria falling under the class of companies, that is based on the paid up share capital or value of borrowing. Both these criteria, paid up share capital and borrowing, will change the impact for rotation of auditor. So the limit of 10 crore, 50 crore, and again 50 crore should be very carefully analyzed regarding the term and rotation of auditor.